Amlex. Hello, Mike. Now I can also see you.
Alessandro, good to see you.
It's a pleasure. So I think, we're moving towards another very interesting sector still on AI. We have this time, different countries involved differently from the previous session. So I leave the floor to you. I know I'm in good hands for, sharing something about the session and then introducing the panelists. So thanks a lot for being with us, to you and the MLEX team today.
Yeah, it's great to be here. My name is Mike Swift. I'm the Chief Global Digital Risk Correspondent at MLEX Market Insight. We're a global news service that focuses on the intersection between technology and the law. Last week, MLEX reported on a lawsuit alleging a cutting-edge Silicon Valley AI startup, employment screening company Eightfold AI, was violating one of the world's oldest digital privacy laws, the United States Fair Credit Reporting Act. Passed in 1970, the same year the Beatles broke up, FCRA classifies companies that collect consumer financial data as consumer reporting agencies and requires CRAs to allow consumers to review and dispute any inaccuracies in data held about them. Eightfold AI, according to the suit, is, and I'm going to quote from the complaint, collecting personal data such as social media profiles, location data, internet and device activity, cookies, and other tracking to create a profile about the candidate's behavior, attitudes, intelligence, aptitudes, and other characteristics that applicants never included in their job application. Because it never got consent from plaintiffs before collecting that data to help decide their suitability to be employment candidates, Eightfold AI is a consumer reporting agency, and it violated FCRA, the plaintiffs allege. Today, we're not going to be focused on the US, but on the EU and Canada. And we have two terrific speakers, one from Europe and one from Canada. That's Andre Verratti and Kristen Pennington, to work through issues around the use of AI in the employment context. Among the topics we're going to discuss are governance and use case authorization, when AI becomes high risk in employment recruitment, data protection aspects, and practical pitfalls and takeaways that legal counsel need to be aware of. But I think it's an interesting takeaway that practitioners in any jurisdiction don't have to just worry about new laws like the EU's AI Act and any legal challenge to new generative AI technology in the employment context. Cases like the Eightfold case, suggest that older laws like FCRA could be significant too. There is also an example of that in Canada, where the Office of the Privacy Commissioner of Canada is investigating whether generative AI chatbot Grok violated the Personal Information Protection and Electronic Documents Act, PIPEDA, which was passed way back in 2000. The Eightfold case also suggests that the courts, as well as industry regulators, at least in some countries such as the US, are going to be key determiners of what AI can and cannot do in the employment context. So let's get into our conversation. I'm going to introduce our two great speakers today. On our left is Kristen Pennington. Kristen maintains a dynamic practice in privacy and data protection law. I should have mentioned, she's a partner at Macmillan in Toronto, I believe. She assists emerging and established companies across a range of industries, providing insights into Canada's distinct laws in these disciplines to support businesses entering or investing in the Canadian market. She also regularly collaborates with international counsel to advise on Canadian privacy law considerations of multi-jurisdictional projects, and she's been a great and authoritative source to me over the years, and I really appreciate that in reporting on Canada. On our right is Andre Verratti. Andre is a partner and he's a partner at VJT Partners, I should say, and he leads VJT and Partners data protection and privacy practice. He has substantial international experience in data protection, digital transformation, and other information technology matters. He's the head of the VJT and Partners award-winning data protection team and the main developer of the legal context of the Adat Solim, I hope I pronounced that properly, GDPR compliance software. That's really very impressive. His experience also includes drafting and negotiating cloud computing deals for both customers and suppliers in a range of industries, including IT and insurance. Thanks both of you for being here. I know we're going to have a great discussion. So I'm going to start off with a question for Andre. Andre, when organizations look at AI in employment recruitment, there's often a temptation to jump straight into the tool or the use case. But from your perspective, where should organizations actually start?
Yeah, that is a great question, and I would definitely pause and step back a bit and not rush with the implementation of the use case, because I think your examples show that if we do not have the right framework for AI compliance, and organizations just accelerate with dozens of new use cases, and they just move fast and break things, that will have a catastrophic impact. So we have to build an AI governance framework first to prevent this acceleration and give a structure to grow and be safe at the same time. And what this governance means? First of all, it means that we have a system to assess each use case, to identify risks, to analyze risks, and put appropriate controls. This process helps us to recognize, for example, whether social scoring of employees is allowed from this example, or can we use emotion recognition in employment context. So use case authorization process is very important. And beyond use case authorization, it is also very important to build up due diligence of third-party AI providers. Because if you don't understand how the model works, whether the model is explainable, how the model could make a mistake, how it could be misused, if we don't understand these basic things, we will not be able to use AI for HR safely. And of course, governance also means stakeholder mapping, because we need ownership. We have to define who will identify and assess risks, who will authorize new HR use cases, who will monitor deployment and implementation of new use cases. So my brief takeaway that you should start with building up this basic governance framework, because if you don't have a governance and implement HR use cases without a governance framework, that will be like driving a car without a steering wheel. You can drive it, but you will not know where you will head.
Well, staying with your steering wheel metaphor, before even getting into compliance, how should organizations decide whether an AI use case is one they should be driving at all?
That is also a very important question. So first, as I said, we have to build up this basic governance framework, and then we will know how to drive this AI car. But after that, once we have this framework, we always have to go back to the framework and comply with the processes of this framework. And this means that we always have to go back to the same use case authorization process. And this use case authorization process, among other things, practically means that we have a process to identify prohibited and high-risk use cases categories, as well as mapping potential harms to assess and mitigate those harms. And what is very important to say here that this is not just about copy-pasting list of AI categories prohibited and high-risk categories from the AI Act. It is not as much straightforward as it sounds, because, for example, if we take emotion recognition, we know that it is prohibited in the employment context, but we also have to interpret what emotion recognition in employment context means. Does it means only psychological state, or also physical state? If from physical state we can infer emotions. So building up processes to interpret these categories is very, very important. And the other thing in a use case authorization process to remember is that it is not just about AI Act labeling, because even if a use case does not fall under the high risk or prohibited category under the AI Act, we could still face risks like hallucination or lack of transparency, and we have to handle those risks. So in any case, regardless how it is labeled in the AI Act, we always have to assess the impacts of each new use case. That is why impact assessment is the key part of the use case authorization.
Wow, that's really fascinating, and it gives you a sense as to how complex some of these legal analyses might be. Kristen, let's go over to you, and let's make this even more concrete and move into recruitment from a Canadian perspective. From your view, when does AI-supported recruitment become legally sensitive, and why does that matter?
Thanks, Mike. Happy Data Privacy Day.
Yeah.
To join you today. I think that it's always legally sensitive, to be quite honest. So one thing to remember about Canada is that although we don't yet have comprehensive legislation that specifically governs the development or the deployment of AI tools, including during recruitment, we do have a patchwork of existing technology agnostic privacy, human rights, and employment laws. And our regulators have been really clear in Canada that organizations that are using AI for recruitment purposes are subject to these laws, even though they may not specifically reference AI right now. So depending on the nature of an employer's business and how many different provinces they're hiring in Canada, an employer can be subject to various different pieces of legislation across various different disciplines, as well as a bunch of guidance that's been released by regulators in various different provinces. And failing to meet these requirements can lead to a variety of legal consequences. You've referenced, a very significant class action lawsuit in the United States. We have the same concept up here in Canada, but also, of course, there are complaints to regulators, investigations by regulators, and in some cases, potentially significant fines. So I'll give you just a couple of concrete examples of the sort of niche requirements that an employer hiring in Canada might not be aware of, but that can really get you into some hot water if you're not aware that they exist before you implement an AI-enabled tool. So one example is, as of January 1st of this year, provincially regulated employers that are subject to Ontario's Employment Standards Act are generally required to disclose in their publicly advertised job postings that they use AI to screen, assess, or select job applicants. So again, the point here is the requirement doesn't arise from any AI-specific legislation. It was actually passed as part of a much broader amendment to general employment standards legislation in the province of Ontario. I'll give you one other example. So in the province of Quebec, which is quite a large market in Canada, their private sector privacy legislation requires that an employer who uses personal information to make a decision based exclusively on the automated processing of that information, they have to advise the individual that they're doing this no later than the time when the individual is advised of the decision itself. And then the individual has the right to request lots of additional information about the automated decision-making process. And they also have to be given the opportunity to submit observations to a member of the employer's personnel who's in a position to review that decision. So again, no specific mention of AI here in this particular requirement, but you can appreciate how it'll often be triggered if your organization is using an AI-enabled recruitment tool for an automated decision-making purpose. So I think the key takeaway here for Canada, like other jurisdictions that don't yet have comprehensive AI specific legislation, is it's still really important to understand the local legal nuances and how laws of more general application can actually impose requirements or restrictions that apply to the use of AI in recruitment.
So it sounds like in Canada, similar to the US, it's super important to be cognizant of provincial law and not just federal law, and that there can be a big difference between from one province to another, right? So
Yes, absolutely.
yeah. That's fascinating. Andre, turning back to Europe, under the AI Act, recruitment is treated as a high-risk use case. Could you just give us a primer on what does that mean in practice for HR teams? Does it affect everyone? And where should HR actually focus?
In recruitment in the EU, AI becomes high risk once it goes beyond administrative support and starts meaningfully shaping the recruitment decision itself. So, for example, summarizing CV is just an administrative task. But if we rank candidates, filter candidates out, or score the candidates with the AI, that could meaningfully shape the final recruitment decision. And that could typically bring this recruitment into the high-risk AI Act category. And if this high-risk category applies, then for this use case, HR should follow all the compliance obligations from the AI Act. And without going into too many details and taking a very deep dive of the AI Act, which is very complex, the bottom line is that employers in such a case particularly need to understand the limitations of the tool they use. For example, they need to know when bias could occur, how outputs can drift over time as the applicant data changes, historically over time. And overall, the employer needs to know what the system can and cannot do. So all these means that under the AI Act, human oversight really becomes crucial, and human review cannot be symbolic. So HR teams must be able to question, challenge, and override outputs in practice. And of course, this goes together with transparency and explainability, because if HR cannot explain why the candidate was ranked lower, then probably something is wrong with the governance.
Great. Yeah. Criticality of human in the loop. Kristen, bringing this back to day-to-day practice, how does data protection come to play in Canada once AI outputs start influencing who is shortlisted or rejected? And does Canada's privacy by design approach, which was originally developed there, help organizations manage this in practice?
Yeah, for sure. So it sounds like we have a lot of overlap with the EU in this respect. So one of the key principles of Canadian privacy legislation, and one of the biggest areas of risk that arises when you're using AI-enabled recruitment tools is accuracy. So our privacy regulators have been very clear that the onus is on the organization that uses the AI tool to take reasonable steps to make sure that the outputs from that tool are as accurate as needed for the purpose. And they've emphasized that this is particularly important where you're using the outputs to make or assist in making decisions about individuals. So that directly relates to recruitment. So long before you actually start rolling out the AI enabled recruitment tool, as Andre was saying, it's important to do your due diligence. So in that respect, we're very big advocates, and our regulators are very big advocates of conducting what we call privacy impact assessments, or PIAs, where you're evaluating the entire life cycle of personal information that will be processed using the AI tool. And you're determining, is this actually fit for purpose? Can we legally use this in the jurisdictions in which we want to use this? And if so, what steps do we need to take to make sure that our deployment of this tool is complying with the various laws that may apply, including privacy and other laws, and also to mitigate any risks associated with using that tool? So we've been helping organizations develop template PIA forms, intake sheets to determine when a PIA is legally required or when it might be prudent to conduct a PIA, and also action sheets and how to track to make sure that you're actually actioning any risks that are identified through your PIA. And having these tools, I think, are in place is really important, particularly if your organization is a frequent adopter of AI tools in contexts like recruitment, because it does help you implement that privacy by design methodology that you mentioned. It bakes privacy and data protection considerations right into your organization's vetting and procurement process, instead of treating privacy reactively or as an afterthought once you've already procured and paid for the tool and are now figuring out how to roll it out.
Mm-hmm. Great. So question for both of you. We've talked about AI risk and data protection separately, but cross-border setups add another layer of complexity. How do organizations actually break down cross-border and organizational silos in practice?
Do you want me to go first, Andre?
Yeah, you can.
Sure. So in my experience, I'm actually seeing more and more organizations that are leaning into more regional privacy compliance and AI governance programs instead of trying to deploy one global standard that meets all of the requirements in all of the jurisdictions where they're hiring, particularly if there are many jurisdictions that are relevant. And I think that's because more and more organizations are realizing that trying to have, one form of notice to job applicants, one form of due diligence checklist for vendors, one standard disclaimer for your job postings, and so on, can become very impractical because there are a lot of local nuances to take into account, but you still want the things that you're drafting and the tools that you're developing to be practical so that people actually use them, and so that job candidates understand what it is they're agreeing to and what's happening with their personal information. Also, the legal requirements are developing very rapidly in some areas of the world, more so than others. And organizations are also starting to become, I find, reticent about offering a higher standard in one jurisdiction than may be legally necessary. So we are starting to see a more regional approach, I would say, to the rollout and the procurement of AI generally, but particularly in the recruitment scenario.
Andre, do you want to weigh in there?
I absolutely agree with Kristen, and we are aligned. I also think that standardization is very important. So I would just add that we really have to develop a common baseline to speak the same language. So we have to have a shared AI terminology, same AI principles, same risk taxonomy, and also common risk management framework. And the good thing is that for all these, there are international standards like OECD AI principle or ISO or NST AI frameworks. And these are pretty agnostic frameworks which could serve as a good baseline and later tailor-made for the organization. I think these international frameworks could help to bridge the silos in a cross-border context.
Great. I think we have a question from the audience. We're rapidly approaching the end of our time, so let's try and get to these. One question from the audience I see here is, privacy used to be a list of legal checkboxes. Now that AI is high risk and automated, has it officially become a problem that engineers have to solve because lawyers no longer can? There's a good question. Do we need engineers to
I was going to say we may be a bit biased with the panelists that you have today, but listen, I mean, I think like any technology, a lawyer that's practicing in this area has to speak the lingo, has to understand the concepts. And I'll never represent that I'm as technologically sophisticated as an engineer. But I think if you're an effective lawyer and you're trying to develop an effective privacy compliance program for your client, you need to understand a baseline of the lingo, and you need to understand who you need to partner with. So who are the internal stakeholders? And that extends beyond setting up the compliance program. Like we can draft a wonderful policy that we think is great on paper, but if you're not able to deploy within your organization understandable role-specific training for the staff that are actually going to be implementing these policies and procedures and responsible for using these tools properly, then your AI and privacy compliance program are not going to be particularly effective. So at the end of the day, you do have to be able to not dumb down, but to simplify some of these more complex technological engineering, concepts, so that everyday personnel who are just doing their duties and responsibilities are able to understand them and deploy these tools responsibly. So I think there needs to be necessarily a seat for everybody at the table in order for your compliance program to be effective.
Great. Andre, do you want to weigh in on that, or?
Yeah, I think that question makes sense, and it is definitely also about engineering. The privacy by design principle is exactly about implementing privacy controls right to the architecture of the AI system, and lawyers and engineers need to work together. There are many engineering questions like how to build up the training data, how to validate them and test them. This all goes, for example, with goes together with the GDPR principle of accuracy, or how to anonymize and pseudonymize data. So there are really a lot of engineering questions, and it is also a very important part of AI governance. In my responses, I emphasize more the governance controls in AI governance, the organizational part, but I think in this sense, technical controls are also very important, and these technical controls belong also to engineering.
Okay. Maybe we'll just do one more quick audience question. We're getting some really great, very, very thoughtful questions. In a world where we can no longer trust our eyes or ears in a remote meeting, how does a data protection officer or a board verify that the person they're, quote, hiring or authorizing is actually a human and not a synthetic clone? I can attest I'm not a bot, by the way, but how would you guys answer that?
Andre, you want to go first this time?
No, ladies first.
I mean, in-person hiring and in-person interviewing is still a concept. So I think it goes back to Andre's point about use cases. And if you have genuine concerns about the accuracy, about your ability to verify somebody's identity and understand that you're speaking to the person that you think you're speaking to, take a step back about whether we really ought to be using that tool. Is that tool fit for purpose? And I do think sometimes, particularly given the pressure that vendors place on potential customers to use certain tools or to really hail the benefits of those tools, we may actually be overcomplicating things that we know how to do. So I appreciate it's a bit of a cop out, and it is a hybrid and remote world these days with different working arrangements. But Andre's earlier point about going back to basics and considering whether this tool actually is something you need to be using is always a conversation that we have with clients before we get into, technically what are the compliance steps we need to be taking here.
Okay. I know we're really at time here, and we all have other things to do today. But just to close, do either of you have really just one sentence to add about sort of this topic, just to put a cherry on top?
Who should start?
You first this time, Andre.
Okay. Well, my short takeaway is that many times AI in recruitment doesn't fall because of bad technology, but falls because a poor organization and governance, because employers do not have governance and do not understand the tool. And if we just follow some very basic rules like understanding the tool, reading the technical documentation of the service provider to understand the limitation, and the HR will be capable to explain, challenge, and control AI outputs, then most of the legal and ethical risks could become manageable in HR context.
And mine is something we didn't have time to really get to, but just be wary of vendors placing pressure on you to accept standard form agreements, which we're seeing a lot of problematic clauses buried in terms of use or standard form agreements, allowing vendors to use your organization's data, including job applicants' data, for their own purposes, including training and improving their AI solutions. So make sure that you're entering into appropriate privacy and data protection terms with your vendors who are providing these tools, and in particular, be alert to any quote unquote standard form agreements or terms of use or click-through agreements, because there can be lots of contractual landmines in there that we want to avoid.
Fantastic. I'd like to thank our two great speakers today, Kristen Pennington of Macmillan and Andre Verratti of VJT Partners. It's been a great discussion. Super questions from the audience. I'm sorry we couldn't get to all of them, but this has been a terrific session. Thank you both very much.